Let's suppose you've decided that you need to file a lawsuit against someone. You're required to do more than just file the initial paperwork, the summons and the complaint, with the clerk of the court to start your case. You also need to make sure that a copy of those same papers is delivered to the defendant in a specific way, following steps that are prescribed by Washington State court rules. Taken together, these steps are called service of process, and this short video will introduce you to the basics of serving a defendant that is an individual person. Serving business or government entities is a little different. Now remember that this will be a very general overview of what can be expected for a typical case. Specific cases or circumstances may have different requirements. If you need further explanations, a law librarian can direct you to appropriate materials. First, a little context. In a civil lawsuit, the person starting the case is called the plaintiff, and the person or entity that they're suing is called the defendant. The complaint is the document that expresses your reasons for suing the defendant. Regardless of whether the defendant is a person or an organization, they have the right to what is called due process or fair treatment. Part of this due process is a right to be notified that a lawsuit has been filed against them so they can answer it. This is so important that the courts require that you, the plaintiff, be able to demonstrate to the court that the defendant was given proper notice. And if you fail to follow these steps, you probably won't be able to pursue your case. We'll go into each of these steps in more detail, but here are the three main steps that have to be followed. First, you will need to fill out and deliver a form called a summons to go along with your complaint. Second, you will need to have someone else deliver the summons and complaint to the defendant. And third, you'll need to file proof with the court that the required forms were delivered correctly. So let's start with the summons. Think of this form as the official notification to the defendant that a complaint has been filed against them. It contains important information about how and when they should answer. Washington State court rules require that the summons contain certain language. This language, along with most other aspects of serving someone, is governed by Washington State court rules. Specifically, it's Civil Rule 4, sometimes just referred to as CR4, and it can be found on the Washington Court's website. By the way, if you're not familiar with Washington State court rules, you should be. There are rules that govern the way that Washington State courts operate. While Civil Rule 4 contains the language required to be in the summons, it's not a properly formatted form in itself, so you'll need to either write one or purchase one from a local law library, for instance. Let's briefly review this sample summons together. Here, in the area called the caption, you must identify the county in Washington State where the complaint is going to be filed. Next, you'll have to properly identify yourself as the plaintiff and the person or entity that you're suing as the defendant. The case number will go over here, but it will only be issued by the clerk once the case has been filed. Below the caption, one of the most important pieces of information contained in the summons is the amount of time that the defendant has to answer your complaint. In this example, the defendant is given 20 days to respond. The time allowed for a response is set by court rules, and 20 days is the most common length of time. Be aware that the time may be different under certain circumstances, such as when you are serving someone who's out of state. The remaining paragraphs in the summons describe the defendant's other rights and responsibilities and explain what might happen if they do not respond at all. At the bottom, you are required to date, sign, and print your name. Also, don't forget to include your address and telephone number, as this is all required. For most people, the next step after completing the summons and writing their complaint is to file these two papers with the clerk of the court. When you file a case with the court, the clerk will assign you a case number and, in some counties, will generate something called an order-setting case schedule, which provides both parties with important deadlines. If you file the case before you serve the defendant, and your county or local court rules require it, the defendant must be served the order-setting case schedule along with the summons and the complaint. Now it's time to serve a copy of these papers on the defendant. If the defendant is a person, the simplest and most common method is called personal service, where a person hands the papers directly to the defendant. In fact, the court requires personal service if it is possible and practical. You've probably seen this dramatized in the movies. The most important thing to remember here is that the plaintiff cannot serve the defendant directly. Washington state court rules prohibit this. The reason is pretty straightforward. An objective, uninvolved person must be able to bear witness to the court that the papers were delivered effectively. Obviously, the plaintiff cannot be that person because they have a direct interest in the case. There are people who do this professionally who are known as process servers. They can be found in the phone book or online. The county sheriff's office can also serve process for you. Using a professional has some advantages. While they do charge a fee, you can be fairly confident that the papers will be served properly, and they may give you a sworn statement that the papers were served in accordance with the rules. This will be more important later in Step 3. But anyone who is over the age of 18, not a party to the case, and is competent to testify to a court that they delivered the papers properly can act as a process server. This can include friends or family members as long as they will make a sworn statement to the court about their service. Ideally, the process server would just hand the papers directly to the defendant, but suppose this can't be accomplished. Perhaps the defendant can't be found. Then there are a couple of other options. One alternative is called service at the defendant's usual place of abode, which is just a fancy way to say the place where they normally live. With this option, the papers need to be handed to a person of suitable age and discretion that also lives at the same address. Note, however, that this cannot include any kind of temporary lodging. If the defendant's usual place of abode is not known, then a second alternative is to serve them at their usual mailing address. If serving a defendant at their usual mailing address, then two things must be done. First, the server has to physically hand the papers to a person of suitable age who lives at the address. Second, they also have to mail a copy of those same papers to that address. After the papers have been delivered to a suitable person at the usual mailing address, service of process is considered complete 10 days after a copy of those same papers have been placed in the mail. Remember, though, that unless you have a court order signed by a judge, you cannot simply mail the papers to a defendant. If none of the options we covered are available to you, then ask your law librarian about the possibility of serving by mail or publication. After you've delivered the summons and complaint to the defendant, the last part of process service is proving to the court that you followed the correct procedures for doing so. You do this by filing a proof of service form with the court. You might also hear this referred to as an affidavit of service, return of service, or certificate of service. This form is used to make a declaration to the court that the summons and complaint were delivered to the defendant as required by the court rules and as described in the proof of service. This form must be signed under penalty of perjury by the person who completed the service. If you've hired a professional process server, they may provide this form to you. But if they don't, or if you've had a friend serve the papers, they must fill out and sign a proof of service form, and you must file it with the court. Once this proof of service is filed with the court, you have completed service of process. It's important to remember that if you're suing multiple defendants in a single lawsuit, you must repeat all of these steps for each and every defendant, including filing a separate proof of service for each one. Okay, so let's quickly recap the highlights. The defendant in a lawsuit has a right to be formally notified that they are being sued, and a right to be heard by the court. The manner in which a defendant is notified is called service of process and is prescribed by court rule, specifically Civil Rule 4. The defendant must be served copies of the summons and the complaint. As we saw in the example earlier, the summons must contain all the information prescribed by court rules. Any person over the age of 18 who is not party to the case and is competent to be a witness can serve the defendant. This service must occur within 90 days of filing the papers with the court. There are three main ways to serve the papers. The process server should first attempt personal service on the defendant themselves. If that does not work, they can try to serve at the defendant's place of abode. If that does not work, they can try to serve at the defendant's usual mailing address. Lastly, you will need to file a proof of service form with the court to prove to them that service was completed properly. Well, those are the basics. If you would like further information about the requirements of service, please visit your local law library where a librarian can show you resources that go into greater detail. Thanks for watching.